Hello, friends. Good afternoon. Good morning. Today, we will say something on the Article 370, which we all know that the same has been finally abrogated from the statute book from the Constitution of India. The Supreme Court has put its stamp, and after the Supreme Court verdict, put my own views on the Article 370 with due respect to the Supreme Court verdict. I will take back you to the situation when this article was abrogated by the executive, the government of BJP. On one sudden day, the proposal was before the parliament, and thereafter the article was abrogated and with the presidential order, and thereafter the statehood of the state of Jammu and Kashmir, erstwhile state of Jammu and Kashmir, was reduced to the union territory, and the erstwhile state came directly under the rule of the central government. And since then, the union territory is under the control of central government, administered by the central government through LG, Lieutenant Governor. Though the demands are there that the statehood should be restored to the erstwhile state, Jammu and Kashmir. Elections should be conducted, but nothing that sort of is happening here, Jammu and Kashmir. Then the deletion of Article 370 was challenged by various petitions before the Supreme Court. And finally, the verdict came yesterday. And the Honorable Supreme Court of India upheld the executive order of removal of Article 370. So I'm basically concerned with this. Uh, we will have some look, some glance on the constitutional provision existed prior to this verdict of Supreme Court. The beauty of constitution is that when constitution is interpreted, nothing can be added to it and nothing can be deleted from it, except by way of constitutional amendment, which may be affected under Article 368 of the Constitution of India. If we meticulously go by the constitutional provisions as existed prior to the verdict of the Supreme Court, the Article 370 was itself exhaustive in nature. The purpose of having this article, the ways to remove this article, everything was provided in the article itself. If you remember, when this article was removed by the central government, at that point of time, the state was not having any legislature. There was no government. And if you go by the provisions of the Constitution, Article 370, though the provision is provided in the Constitution itself that this is a transitional provision, temporary provision, and by presidential order, it can be removed from the statute book. But at the end, there was clause inserted to this article which very clearly says that before its abrogation, before such proposals, the consent of the Constituent Assembly is mandatory. This procedure is very clearly laid down in the Article 370 itself, that before its removal, the consent of the Constituent Assembly is mandatory. It means that, as I have said, that when we interpret the Constitution, the rule of interpretation is that you cannot add anything to the provisions of the Constitution and you cannot subtract anything. You have to interpret it as it is existed. Now, the point which is just rolling in my mind is that can this Article 370 could be removed as it was removed by the central government without seeking permission from the Constituent Assembly. If we go by this analogy, that at that point of time, there was no any legislature, there was no assembly, there was no. Then the next question which arises here is that then the government could have been waited till the legislature is formed. And when this proposal of deletion is moved before the legislature, then while considering, deliberating on that proposal, the legislature could act as constituent assembly because the proposal is to remove the provision from the constitution. As in the parliament also, when parliament amend constitution, then it amend the constitutional provisions, assuming itself the position of the constituent assembly and not an ordinary legislature. The same could have been here also in this state, but unfortunately, without waiting to have the legislature, the central government removed this article and reduced the status of the state into union territory. So this point is still emerging, rolling in my mind, that after all, what was the object, the purpose of incorporating the provision, the clause, which clearly laid that before the presidential order is passed, the Constituent Assembly consent was must. That point is still hovering. As a constitutional lawyer, that point is still hovering in my mind. What was that? What was the purpose of that clause? Why that clause was inserted in the constitution when this Article 370 was incorporated in the constitution? Then why this clause was inserted that the consent of the Constituent Assembly is must? I now, since the verdict has come now, Supreme Court has finally laid this provision at rest. But that question of Constituent Assembly, it still remains in my mind. Its purpose is still in my mind. That what was the wisdom of incorporating that provision, that clause in the constitution, in the Article 370? That remains, will remain there. So this point was hovering in my mind, which I wanted to put before you. Hope what I have said, you will also deliberate on this point and answer this, that can, without seeking the consent of the Constituent Assembly, the central government can opt to abrogate this article, though now it has been put finally by the Supreme Court of India. Thank you. Thank you very much.